Hello, everyone, and welcome to my case summary of Louisville and Nashville Railroad Company versus Mottley. This is a Supreme Court case from 1910. It was unanimous, and it's a really important one if you're in a civil procedure class in law school and you're learning about federal question jurisdiction. One of the two ways that a federal court gets jurisdiction over a case is if there is a federal question involved. The other way being diversity of citizenship between plaintiff and defendant of different states. So this is still good law, very old case and very important, but also pretty simple. So let's start with the facts. The Mottleys were hurt by a train accident. The defendants gave them lifetime free transport to compensate for this. So Congress passed an act prohibiting free transportation. So the defendants stopped giving them free transportation because of that law. It was against the law. So the Motleys were understandably upset by this, so they sued for specific performance, alleging there was a breach of contract and that their complaint sought an anticipated defense pointing to the act by Congress. But they argued in response to that defense that they anticipated that the due process clause of the Constitution invalidates Congress's act. So there would be federal jurisdiction, in their view, over their claim for breach of contract. Now remember, breach of contract is a state law claim. States are authorized to decide their own contract laws. Normally, if it's citizens of the same state suing for breach of contract, it goes to the state courts, and federal courts are courts of limited jurisdiction, so they do not hear state contract claims. So the big question is does the anticipated defense that the Mottleys mentioned in their complaint allow the federal court to exercise subject matter jurisdiction over their claims? Now, there was this case from 1824, Osborne versus Bank of the United States, that held that as long as there is a federal ingredient in the action, then Article 3, Section 2 grants federal jurisdiction over it. Article 3, of course, being about the power of federal courts, saying that they are of limited jurisdiction, but giving them that power nonetheless to hear cases between citizens of different states and cases that arise under the Constitution or laws of the federal government. So Osborne took a broad approach to federal question jurisdiction, but Mottley is going to end up taking a more narrow approach on the matter. So what does the court say? Well, they hold that there is no federal question jurisdiction here. It's just not enough to allege an anticipated defense to their action and assert that the defense is invalidated by a constitutional provision. We needed to see something that invoked federal question jurisdiction in the complaint. Now they bring up, and this is sort of dicta, I guess, but those allegations might show that in the course of the litigation, some constitutional question would arise, but they don't show that the plaintiff's cause of action arises under the Constitution. And it certainly clearly does not. This is a cause of action under state contract law, as I said. And generally, courts are going to follow what's called the Holmes test, the creation test for this, where they look at what created the cause of action for the plaintiff. Is it state law? Is it federal law? And if it's federal law, then there is federal question jurisdiction. It passes the creation test. But sometimes, and there are cases on this, where a claim may not pass the creation test, but federal question jurisdiction still is had by the courts by virtue of the fact that federal law is basically necessary to resolving the dispute, and it's totally raised, and the dispute can't be resolved without federal law. So the bottom line is this. We have this thing called the well-pleaded complaint rule for our federal courts. The courts are going to examine the four corners of the plaintiff's well-pleaded complaint, and then they're going to determine, based on looking at the complaint from each of its four corners, if the plaintiff has raised any question of federal law. And of course, as I said, that federal law needs to be necessary to resolving the dispute. It needs to actually be raised. It needs to be prominent. It can't be dominated by issues of state law. Otherwise, federal courts are not going to be exercising subject matter jurisdiction over that claim. But yeah, that is Mottley. Pretty simple, pretty straightforward. fundamental to understanding civil procedure and federal question jurisdiction. If you like this video, if you found it helpful or insightful, please leave a like, comment, or subscribe to the channel. I'm here to help you get an A+ in civil procedure. I want you to absolutely ace that thing. And as always, thank you so much for watching, and I look forward to speaking to you in the next video.